Taken consent of the other side. You have taken consent of the other side. Okay. 27, both sides are represented on the prayer made by learned counsel for the appellant. List on, give a date. Okay. Just wait. So your seniors are waiting. 41. You want to file affidavit in reply? Okay. You have informed the other side? Okay. Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned to enable the petitioner to file affidavit in reply. 41. List after 2 weeks. '51. Mr. Sharma, you have examined this 51. Mistake of address, you can correct it. You want the amendment of the cause title. In the order, we don't give the SP border. Okay. Make that correction. A cause title, amendment of cause title, and direction to SP. Which SP? SP? SP border Bongaigaon. It should be Bongaigaon. Okay, then upgrade. We'll upgrade and take it. Yes. Just wait. Your seniors are there. Okay. Rejoinder in the interrogatory application. In the main rate petition. Okay. All sides are represented on the prayer made by Mr. A.R. Bhuiya, learned counsel for the petitioner. The matter stands adjourned to enable the petitioner in WPC 1392 of 2025 to find rejoinder affidavit. List after 2 weeks. Okay. Yes. '19 is a PIL. This is the item. Just wait for some time. Item 19. Yes, next. Next. Okay. 91. Okay. Okay, both sides are represented. You are for on the prayer made by learned counsel for the appellant. List on. When do you want? When do you want? It goes to next Friday, 2020 to 2026. Okay. Okay. We'll take it up on Monday then. 7. Monday. Both sides are represented on the prayer made by Mr. U. Dattar and counsel for the petitioner. List on 16-2. 33. Yes, this. Pardon me? Please put on your speaker. Is it on? Please repeat again.
As directed by this honorable court, my lord, I need some time to take dusty service.
33. The prayer made by the learned standing counsel for the
Elementary, I am appearing on behalf of NJ Khatoni, my lord.
okay. The standing counsel for the elementary education department. Matter stands adjourned to enable the state to serve notice on the respondent through justice service. Steps within
3 weeks, my lord. My lord, I will file affidavit, my lord. That's why, my lord.
you have taken steps or not taken steps?
My lord, I have not taken, my lord.
Okay. Today's time is out to take steps to stop the registry. Upon processing the same, shall hand it over to shall hand over the process to the counsel for the state to serve notice by way of Dasti. Post of the notice is made returnable on, give a date after 3 weeks. Returnable on so and so. List, the affidavit of service shall be filed prior to the next date of listing. List on so and so. Yes.
May I please, your lordship? Lordship, item number 38, 39, 40, 42, 43, and 44 are connected matters, your lordship. Lordship has given a liberty to collect the pre-consignment from the registry and submit it before this honorable court. Lordship, I have filed an affidavit of service today, your lordship. If lordship allows, she may be called for your lordship. Much obliged.
Wait, please, your lordship. I beg to mention item 25. It is an appeal by the union, my lord. We are appearing for the other side. We will file our wakalat number today.
25.
25.
You've informed the other side?
Informed.
No, then.
Okay, both sides are represented. Mr. I. Botago, learned counsel, submits that he is instructed to appear for the respondent. It is for some time to file affidavit, wakalat in the matter. Has to accordingly list the matter on.
Any date, man, after a week.
Give a date after a week.
No.
Okay.
Problem.
May please, your lordship. Lordship, item number 4 may be taken any other day. My senior is not present today.
Item 4.
Yes.
Okay. When do you want? When do
Any
you,
date.
okay, Friday make it. Both sides are represented of the prayer made by learned counsel for the petitioner, list on so and so. Yes.
May it please your lordship. Your lordship, I'd like to mention item number 20 on behalf of my senior, Mr. A. Narjiri. Your lordship, I have already taken the prior consent of your other side. Kindly may the matter be listed after 2 weeks.
Just wait this PIL matters. Just wait for some time. When PL matters, we want to see the records, why it is lifted.
Wait for some time.
Just wait for some time.
Wait, please, your lordship. Lordship, I beg to mention item number 31.
31.
Yes, lordship. We have taken consent from other side, lordship. 31, lordship.
31, this again is PIL.
Yes, lordship.
Just wait, we'll look into the records and give.
Lordship, pass over for the tail.
Just we'll have to look at the records and then.
Item 19.
Yes, my lord. Actually, in this case, commissioner report has been done, collected, and there was some then government also has filed their affidavit. In the last session, the honorable Chief Justice said that they will be passing an order today, but then today I'm not really very ready for doing further hearing. Again, another date, madam.
You're for the petitioner.
Pardon me?
You're
Yes,
for
we
the-
are the petitioner, madam.
Also the representative on the prayer made by the council for the petition. List on, you can fix it.
Item 20.
You're paying for an adjournment.
Yes.
What size is presented? No, not what size. The petitioner and the state respondents are represented on the claim made by the counsel for the petitioner. This is adjourned today, this one. Give a fixed date. Last. Give a fixed date.
Item 31.
Yeah, same. Who's with the education department?
We have already informed Lordship.
My senior is on to this.
We informed Mr. Khatun, Lordship.
You're for the state?
Lordship, they want to seek some.
No, it's okay, but what happened to that, that certificate, has it been issued?
Lordship, Mr. NG Khatun appears in this matter, Lordship. He's on his way, Lordship.
No, because you see here it's a question of admission of a student
Lordship.
under RTE Act. If we adjourn the matter for 2 years, what will be the status of their education? That economically weaker section and then BPL, they have a right to education.
Lordship.
So what has happened to their education? We are adjourning this matter for so many, about more than 2 years. What has happened to those children, 4 children?
Lordship, the status, Lordship, Mr. NG Khatun will appear.
Mr. Khatanya, what happened to these 4 children? What has happened to these 4 children?
Sorry, my lord.
Are they continuing their education? These 4 children who are supposed to get a certificate,
Yes, my lord.
have they got the certificate? Are they carrying out their education?
My lord, pardon, my lord, I am not.
These 4 children for these 4 children, this PL was filed,
Yes, yes, my lord.
seeking the certain certificate to extend that RTE to them.
Yes, my lord.
Now, what has happened to them? Are these 4 children studying or they are out of school?
No, my lord. Basically, they are seeking implementation of section 12, 1C, my lord. And we have taken steps for implementation thereof, my lord. Whatever step we
We
have
are
taken,
concerned with the steps for implementation. We are concerned with this career of these 4 children. What has happened to them?
they are studying, my lord. Whoever got the last year, whoever got admission,
You see, if they are studying in this, only these 4 children, the case of 4 children were highlighted. Is it not?
yes, my
Anything survives here?
yes, my lord. In fact, what steps we have taken, we have already bring it on record by way of an affidavit, my lord.
No. We can get that.
Yes,
The problem is that this PL was instituted because of these 4 children.
yes, my lord.
Have we expanded the scope to cover everyone in this PL? You see the prayer here.
Now, kindly see the prayer at page 26, my lord.
Yes. So this student admission for the academic year 23-24.
No, the first prayer is to issue direction to state responsible to appoint nodal officer at the district level for purpose of section 12(1)(c) of the RT Act,
Yes.
who shall play a role in raising awareness regarding admission process so and so, so and so. Then, my lord, second prayer is regarding, my lord, state responsible to upload list of students admitted under so and so for 23-24.
That is gone.
Yes. Then, my lord,
Second is office members.
third, create a management information system software in line with part B, clause 7 of the OML. Then issue direction to the state responsible to create centralized system through the means of a web portal. So that we have developed, my lord.
You file an affidavit to that effect.
Yes, to that effect, we have filed an affidavit, my lord.
And then this centralized system means of a web portal.
Yes.
This is there.
We have introduced it, my lord. Last year, we have introduced it, my lord.
Last year.
Yes, my lord. For last academic year, we have introduced, my lord.
A nodal officer has also been appointed. No. Nodal officer has been appointed.
No, my lord.
Let's see 12(1) RTE Act.
Lordship, I appear as petitioner in person in this matter, Lordship. What happened on the last date was they had filed the affidavit stating their inability to comply with some of the prayers which we had. So Chief Justice had fixed this matter for today to pass necessary orders. So,
That's why we can understand that.
Lordship, so I was under the impression that we would be seeking adjournment.
We somehow, our attention was caught to the fact that for 4 students, this was
Yes,
being
Lord.
taken up. So what happened to, the first concern was what happened to those?
31 students, out of that 31 students were admitted after filing of this
Ah.
PI Lordship. After multiple orders of this court, they got admission, they are still studying. Now we are on a bigger issue. The bigger issue is having a website of all the schools which come under 12(1)(c) Lordship. And the other point is the vernacular part. The state government had said, the state government came out with a notification that only the vernacular schools would be registered. So we have raised a objection to that, and we have put our objection in the form of an affidavit in reply against which the affidavit the state has filed, Lordship.
Right of children to fair.
So on the last occasion, we have filed a reply, which is already, I think it's in the record today. The last वाला affidavit है ना? Last वाला कौन सा? ये नहीं 23 के बाद वाला जो का है. नंबर में फाइल की. ये ये common claim chief is going to pass orders. He said on the last week, no? He wanted to.
Mr. Attorney,
Yes, my lord.
you see, that is the only thing. We observe in the order that if no nodal officer is being appointed by the state, it's the state's prerogative, you may appoint, you may not appoint. We can't do anything because section 12 doesn't have that, what you call the provision for a nodal officer. Then we say that within time limit prescribed by us in the order, the secretary to the Department of School Education will monitor this, and he'll
No,
be.
Lordship, that is not our only prayer. We have many other prayers, Lordship. And appointment of the nodal officer is there in the OM, Lordship. If I may take Lordship,
OM.
there's a OM issued by the state, Lordship. Meanwhile, petitions are there.
No, because part of the prayer which you are making
Yes, Lordship.
is already been addressed, page 59.
Lordship will give me a second, Lordship. Lordship, my PI page 39, Lordship. May
Page
kindly
39
come.
is that office memorandum,
Yes,
12(1)(c). Yes.
Lordship page 39. Lordship may kindly come to admission procedure, Lordship. That is one, and the second one which we are following is activity calendar, Lordship.
No, because
First, that activity
no.
calendar was never in place, Lordship. Even till date, in the absence of a website, this activity calendar has not been followed, Lordship. So we are continuously arguing on this matter that the website should be there. These schools mandated under 12(1)(c) should register
Yes,
their
there is a
vacancy.
website.
They have a website, Lordship. On the last that we had shown this code that the website has registered schools. On the drop down, it shows if a child has applied from Kamrup, the schools are in Nalbari or in Borpeta. We don't have a school in the vicinity of 5
Okay,
kilometers.
provide bus. What is the problem? Morning breakfast, afternoon lunch,
Lordship,
evening tiffin and send back.
in their last affidavit, they have stated their inability and we have filed a reply. So, Honorable Chief Justice had said that on the next day he would be passing appropriate orders, Lordship. They have admitted that they don't have a
Yes.
proper website, Lordship.
You will deposit 1 crore rupees for each district to provide for buses, provide for morning breakfast, afternoon lunch, evening, what you call tea. If you collect children from one district and send to another, you will be feeding them definitely. State won't say no.
Please, issue here is that they can admit anywhere, in any school, any private school, they can admit under section 12(1)(c), my lord. But this is not a case that my lord is.
No,
There is
trust me,
no school.
I am a below poverty line person.
Yes, my lord.
You are providing me with with all the BPL people with the tab, laptops and all to see your website. If I want to get my child educated, I am a BPL person.
Yes, my lord.
Please tell me, how will I do it? We are ready. Both of us will be ready to go to any school of our choice and make an application for admission of our child there.
Yes, ma'am.
Can we go today? School of our choice will say, 4 o'clock we'll go to a school of our choice. Any government school, you can give us a list, because I don't know the name of the government schools in Gauhati. Give it at 4 o'clock, we'll go, both rise and go to that school. Try to have my child admitted there. Give us a name in the afternoon at 2 o'clock. Give us a name. We'll give you the, we will choose a school and then tell you the name. At 4 o'clock, we are going. We'll visit that school, have our child admitted there. Let us see. Two o'clock, give us a list of schools around where we can easily move. Because if you give us a school name of school at Nalbari, all the people at Nalbari will have to wait for us till we reach there.
Well, obviously, everyone wants a school near to his residence or.
No, we are not on that. We accept your statement. You are giving me an admission in Nalbari. But at 4 o'clock, if we rise and go from here to there, instruct your officers at Nalbari to be there
No, my lord,
till we reach.
this is not the case, my lord. This is not the case. Oh, my lord, the concern.
Give us a very simple solution. We both want to get, we are BPL people, we want to get our children admitted in a school. Give us a list of schools where we can get it admitted.
Here, my lord, Gauhati, within this High Court area, is various schools, my lord, college at Kamrup
Tell me
Academy.
one name.
Kamrup Academy, Cotton
Kamrup
College.
Academy, okay. We'll go to Kamrup Academy. At 4 o'clock, we are going there. We'll try to have our, see the admission process. Kamrup Academy.
Here's a fast lordship in the website.
Let us see if they have made it. We'll see.
Lordship, I can just bring Lordship's attention to page 40, Lordship. The serial 11 says the unaided private schools shall admit children under section 12(1)(c) under RT Act 2009 as per neighborhood norms. Children residing within a distance of 1 kilometer for getting admission into classes from 1 to 5, Lordship. Children residing within a distance of 3 kilometers for getting admission into classes from class 6 to 8. A proof of certificate regarding the neighborhood may be obtained from the concerned village head or Gaon Bura, secretary of the GP in rural areas, so and so. What has exactly happened is, Lordship may find this note in the file, Lordship. We had given this in before court number 1. They did come up with a website, Lordship. And Lordship, this note says, note presented by the petitioners concerning present status of implementation of 12(1)(c). On 23rd of May 2025, we had submitted this before the Chief Justice. Lordship, it says there is a screen, there is a website. First page, when we open, registration comes, we register. Then on the second page, Lordship, when we click the admission form shows upload documents, and when we and before that, Lordship, it comes admission form, address to address. When we have already registered, when
This,
we come.
this is the note.
No, Lordship, this one with a drawing on it. To make it easier, we had taken screenshots of the computer as in how we processed with the website, and we placed it before this court, Lordship. And Lordship, I can give you my copy, Lordship.
Do you have it?
Yes. Image 2 shows, Lordship, that was on 22nd May 2025. When we go proceeding for choosing a school, the child is presented with only a list of 9 schools, Lordship. And those schools are not within the vicinity of the neighborhood where the child resides. If Lordship looks at the next image, image 3, it is
Admission form of image 3.
Yes.
This Kamrup Academy is not there.
No, it is not. They never registered, Lordship. It is mandatory for the schools to register. It is there in the act, but till date, hardly any schools have registered under this website, Lordship. And Lordship, if Lordship comes for the selected schools, it shows 25, 26. Because 2 years we worked, we did not have any website. None of the children could go. And schools have formed a new thing. They are taking the children of the driver or of the maids working there, and they're showing it as they're working under 12(1)(c). But in fact, those people have come and told us that they pay 25%, 50% of the fees. It is supposed to be free, and it is an unaided private schools. And now the state has come out with a circular notification that under 12(1)(c) only vernacular schools would be registered. And we have even brought that up before this court, and chief had asked them. What, where is your affidavit? Dear Namo, affidavit. Lordship, the state's affidavit, Lordship, which they filed recently on 1/11/25. They have come out with completely giving a go-by to the act. They have come out with their own rules and own guidelines now. Nowhere in the act it says that vernacular schools ought to be registered under 12(1)(c). So we have even challenged before this court for that now, Lordship. Lordship, in my note, if Lordship sees, we have brought it up in this note only in the month of May last year, limited to vernacular medium schools only.
Affidavit of which date?
Sorry, Lordship.
Affidavit filed on which date?
The government has filed on 1/11/2025. And Lordship, we have filed a reply also to that.
Ready?
ये वाला नहीं, ये नहीं, ये तो दिसंबर में फाइल किया। चलिए लास्ट करो। तो उसके बीच में भी एक होगा।
Yes, ma'am. Yes, ma'am. Yes, madam. Yes, madam. Yes, madam. Yes, madam. Madam, this portal is in pilot stage, madam. That is why maybe there may be some misinformation. Yes, my lord. Yes, my lord.
For the individual schools, in fact, they have no grievance against us, we find our detailed affidavit. And we have been complying with all the provisions of the act. We are a special category of schools under the Kendra Vidyalaya also. One is for IIT, one is for Companion Railway, and one is for Narangi area. So all these cases, we filed a detailed affidavit and they do not have any grievance against us. No, Lordship, at the moment, let them be there because we have new new cause of action, Lordship. Last 2 years, I've only been here with nothing. Yes. My presence is otherwise not required. No, I'll be declared. Yeah, I had your Lordship before. At the moment, we don't need, at the moment, the private respondents are not, we have nothing against them, but there are fresh cause of actions which will bring up Lordship.
Obliged, Lordship.
मुझे को बोलना दो बजे आ जाएगा.
Item 1 for motion.
please, your lordship? Lordship, kindly pass over for time being. Yes, lordship.
Item 2 for motion.
May I please, Lordship? Lordship, as per order dated 28 August 2019, Lordship, there was an interim order and party was appeared, Your Lordship.
Where is your written statement? Which page?
WS,
Yes.
page 8, Your Lordship. Annexure 8, Lordship, page 41,
page.
page 41.
स्टेटमेंट में सब कुछ आना चाहिए मेरा साइटेशन लिखा दो
But you have hardly exhibited any document. Exhibit A and B is certified copy of the voter list of 1966 and 70. Exhibit C is the Gampura certificate. The Gampura was not examined. Page 54. Then you have no document to connect. You're producing some documents now.
not placed before the tribunal lordship.
No, not produced. Your father is not in the any voters list after 1970. And you said that your father died. You don't give the date of your death of your father. Mr. Karim, there is no document to prove anything.
After 1970, Your Lordship, page 32. 1989, Your Lordship, voter list.
So those are not exhibited. We first look at the exhibited documents, then we see if there are any other documents. And how does this Javamandi at page 21 help you?
21. Lordship, it's my grandfather's name, Your Lordship. Abdul Ghani Dawan, Your Lordship. Nineteen 58 to 59 years. Chittagong. Page 18 years.
What is the name of your father?
Page 18, Annexure 1A.
What is the name of your father?
Urpan Dewan, na? Name of the forest Afan Dewan, Your Lordship. Afan Dewan.
Then there is no continuity. There is no continuity. Your grandfather is Ramjan Ali.
No,
Then
grandfather is Abdul Ghani Dewan.
Then who's-
Ramjan is my name, Your Lordship. Ramjan Dewan.
is your
My name is Ramjan Dewan, Your Lordship.
you are Ramjan Dewan.
Lordship. My father's name is Afan Dewan. Arfan Dewan.
Arfan Dewan.
Ghani Dewan is my grandfather's, Your Lordship. On Urpan Dewan name is, that is my uncle, parental uncle, Your Lordship. Original Chittagong, page number 18, Annexure 1A. Subsequently corrected, Your Lordship. Page number 21, Annexure 1B. Wherein my name also shown as Ramjan Dewan, Your Lordship.
Which page?
Page 18, Your Lordship. Annexure 1A. It is 1958 to 59 documents, Your Lordship. Name of the Pattadar, Abdul Ghani Dewan, Your Lordship. This is my grandfather, Your Lordship. All documents are related to village Goma, Your Lordship. Same address, Your Lordship. Lordship, 21, Your Lordship. 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 Is subsequently, Lordship, annexer, Your Lordship, in this writ petition, Your Lordship, but in document listed. It is not annexed in the WS, Your Lordship, page 43, Your Lordship. Lordship. I annexed the writ petition, Your Lordship. It was not annexed to the WS, Your Lordship, at the time, Your Lordship. That's why my prayer for reconsideration, Your Lordship, return, Your Lordship. But
Lordship, he has annexed voters list of 66 and 70, Lordship, grandfather and father. Not a single voter list to show father with the petitioner. The 1988 voters list, it was never exhibited before the tribunal. And the 1997 voters list is an extract which is not an admissible piece of evidence, Lordship. Then the Gaubura was not examined, the certificate which he has placed, and even the land documents which has been placed before this court but not before the tribunal, Lordship. So there is no direct link of him with his projected father, mother, or grandfather, Lordship. The WS is very vague. If Lordship looked into the WS, material facts pleaded are not there. What he has brought before the court now, it is not there.
the documents were subsequently collected, Your Lordship, due to proper lack of advice, Your Lordship. We have the sufficient documents, but voter list page number 32 for first time exhibited voter list, Your Lordship. There's an example note was exhibited, Your Lordship, on the WSR evidence, Your Lordship, subsequently collected, Your Lordship. Says
He's
certificate
marked the
to
Lordship in the 1997.
but my name was there, Your Lordship, and
No, his not a single
At the
voter list
time of-
was exhibited, Lord. 89, which he has brought before this court now in this writ petition, it was not there.
there's
It was
another
never
issue.
exhibited before the tribunal.
As per this voter list, my age was 20, Your Lordship.
But his PAN card shows he was born in 70. He has even annexed
it.
his PAN card. Yes,
And
born in
that
70. So the projected grandfather, father, and the petitioner, the linkage is completely missing, Lordship.
in the 97, my D was tagged with the name, Your Lordship, my name. First time, 1989, my name was shown, Your Lordship. Age also proper at the time, Your Lordship. Only prior to one chance, your lordship, to produce these documents, your lordship. Before that, you would, your lordship. Due to lack of proper advice, your lordship, and not available of the document, that these documents also not annexed at that time, your lordship, but I have sufficient documents, your lordship. Land record from the year of 1958 to 59, your lordship, and also 60 to 70.
58 to 59, lordship.
And those documents was subsequently corrected. My name also recorded there, your lordship. I also pay the land revenue, your lordship, till date, your lordship. After revenue, your lordship, that's why, your lordship. That's why my prayer, one chance to produce these documents before the tribunal, your lordship. Answer. And this petitioner is a illiterate person, your lordship. Thumb impression holder, your lordship. No sufficient knowledge, your lordship, about the procedure, your lordship. That's why I failed to collect those documents that at the time of submit evidence, your lordship.
Petitioner also heard so-and-so for the respondents. Next part. My filing this writ petition in Article 226. Opinion is at page 54.
66, 94, 97,
Passed by so-and-so. In FT case number so-and-so. Reference IMDT case number so-and-so. They were declaring the petitioner to the
66, 72,
foreigner post in 1971 scheme.
89 over the next.
Next week.
Judgment.
The
80.
learned counsel for the petitioner has submitted that although the petitioner has sufficient documents to prove his lineage to his grandfather, whose presence is available in the land revenue records of the year nineteen 59. For which reference is made to the copy of Jamabandi, which is annexed to this writ petition as Annexure 1 capital A and 1 capital B. Project that the petitioner had inherited a plot of land from his father White. Petition order dated 1996. From his father, namely late Kurban, K-U-R-P-A. Kurban spelling would be K-U-R-P-A-N.
Lordship.
Kurban Dewan.
Who is parental uncle, your lordship, of the petitioner? Parental uncle of the petitioner, Kupan Dewan. Arfan Dewan is my father. Kupan Dewan and Arfan Dewan both are brother, your lordship. Son of Goni Dewan.
Arfan Dewan is your father.
Lordship. Kupan Dewan is my uncle. Both are son of Goni Dewan.
No, which is your name?
My
Your
name is
Ramjan Lord.
Ramjan Dewan. Son of Arfan Dewan.
So Ramjan doesn't come to your land. Your name is not mutated here.
Mutated, your lordship.
Where?
Page number 21, serial number 5, your lordship. Column number 3.
No, remarks shows for remark at column 10.
Column 10, your lordship. Lordship. At the bottom, your lordship, Eknong Pattadar Espolot, Mohammad Ramzan Dewan,
This is
Pita,
not Ramzan.
Ramzan Dewan, your lordship.
No. Ramzan Devan Pita Kurban. We asked
So
you
it
this.
is
You said
wrongly
no.
written, actually, Kurban is uncle.
Can't be.
Father name
This
is
is not raw.
Arfan, your lordship.
This is last line is not raw. At least we can't read raw. Tamjan is something like Tamjan
Ramzan.
or Amjan. Amjad. Amjad. Amjad.
Lordship, it
Amjad,
got
yes.
Yeah.
Oh, lordship, middle is there, your lordship. 2 নং পাট্টাদার স্থলত রমজান দেওয়ান পিতা আরফান দেওয়ানের নামত নামজারি করা হয়। If the middle,
Okay.
go, your lordship. Go.
Who inherited the land from late Arfan Devan. And that is father and the uncle of the petitioner. No, and the the grandfather of the petitioner inherited the land from his father, namely Sri Abdul Ghani Dewan. It is submitted that due to ill advice from the learned counsel holding the brief for the petitioner before the learned tribunal, these documents could not be exhibited. So accordingly, it is submitted that in view of the documents which were subsequently procured, the petitioner has been able to make out a case for remand of the matter to give the petitioner an opportunity to read further evidence in the case. Next. Per contract, the learned standing counsel for the FT and border matters has submitted that the petitioner had merely exhibited 4 documents, being 4 documents, but out of which the petitioner claims relies on the voters list of 1966 within bracket exhibit A and voters list of 1970 within bracket exhibit B, which discloses the name of grandfather, grandmother, etc., and the father of the petitioner. However, the name of the petitioner does not appear with his projected parents or grandparents, and the date in which the father of the petitioner had expired is also not pleaded. Accordingly, it is submitted that the voters list of 1997, where the name of the petitioner appears as D voter, is not sufficient to prove the existence of the father and grandfather of the petitioner before 25/3/1971. Next paragraph. The records of the tribunal reveal that the petitioner had filed his written statement on 12/4/2017. It is stated before the learned tribunal on 12/4/2017, where he had stated, amongst others, that he was born and brought up at village Goma, Goma, Moza Chenga, Chenga, PS Talabari, in the district of Barbeta, where he is residing. The name of his father is Arfan, ARFAN, Arfan Diwan, and name of mother is Rabia, RABIA, Khatun. His father had expired and the mother was alive. And after the death of her father, when the petitioner was about 5-6 years old, his mother came back to live in her parental house in the same village. So the petitioner stated that the name of his grandparents, namely Goni Dewan, Goni, Dewan, DWN, and Moziron, Moziron, Nessa, and name of his father, Arfan, were recorded in the voters list of 1966 and 1970. And the name of the mother of the petitioner, Rabia Khatun, was recorded in the voters list of 1997. However, his own name was shown as D voter in the voters list of 1997. So the petitioner has a certificate from the Gauhati as proof of residence. Next, provide the evidence on affidavit, the petitioner had dated the statements made in the writ petition. And in support of these statements, the following documents were exhibited. Page 46. Exhibit A, B, C. It may be stated that apart from exhibiting 3 documents, the petitioner had annexed a copy of voters list of 1997 as Annexure 1 and to Roman 1, Roman 2, the evidence on the affidavit. In his cross-examination, the petitioner has stated that his mother, name of his mother is Rabia Khatun, and the name of his grandfather is Gani Dewan. His father has died and mother is alive. And his name appears as D voter in the voters list of 1997. He has always stated that his grandfather and father's name appeared in the voters list of 1966. It stated that Kurpan, Kurpan, the one was his uncle who had expired. Next. The petitioner examined his perfected mother, Rabia Khatun, as PWQ. We don't know, Mr. Karim, how this written statement is prepared. The readings is totally poor. Now with your evidence, you disconnect your father and your mother, and then you don't give a description of how you inherited the land. You say that your father died. Your mother, you use the word fled away to a parental home.
Getting married.
So if she has fled away, that means there is a disconnect from the family. How do you inherit? You have not given a statement. Very surprisingly, in the evidence of DW2, she doesn't write the name of her husband. That is only given in the first paragraph, which incidentally is not a statement on oath. I so and so, aged so and so, wife of so and so, is a statement which is not made on oath. Here under section 50, your relationship is required to be proved.
DW2 is aunt, Your Lordship. Aunt of the petitioner, Your Lordship.
Aunt.
Aunt. Kurpan Ali, Kurpan Dewan is uncle, Your Lordship.
No.
Lordship, para 3, Your Lordship. After death of my younger brother-in-law, that means my father.
If she is the wife of Arfan Dewan, he is your mother. He can't be your aunt.
No, my mother name is
Rabia Khatun.
Rabia Khatun.
She is
And
Rabia Khatun.
DW2 is
Rabia Khatun.
no Nabjan Nasa, alias Kabjan Nasa, but Nabi
We
Nasa.
don't know. Page 49 of the writ petition, we are reading is DW2 is Rabia Khatun. What you have annexed, we don't know. We are reading what you have annexed, DW2.
Is 52 also. Lordship.
49.
49,
52 we have
Your
not
Lordship.
reached.
49. Wife of late Arfan Dewan, Your Lordship. Rabia.
But that's not a statement on oath. No, in no
On
affidavit.
oath, there is no statement, Your Lordship.
In no affidavit, you say that I am so and so is a statement on oath. That's the problem. We find disconnect.
Actually, the trial procedure in the landed tribunal, Your Lordship. So mechanically, Your Lordship, that
We don't know. We can't accuse anybody
actually
of
it's a fault
acting
of the
mechanically.
landed engaged counsel, Your Lordship, of the
We
tribunal, Your
say
Lordship.
that.
Actually, the petitioner is only illiterate, Your Lordship, thumbprint, that's how he should issue the notice, Your Lordship, to the Gaura and to this person's, Your Lordship. And document, Your Lordship, is sufficient, Your Lordship, for this, for him, Your Lordship. Then documents, but that was not enclosed, Your Lordship. So but 66, 70 to 89, Your Lordship, it's sufficient to connect it, Your Lordship. But that's why I only prayer, Your Lordship, or retail, Your Lordship, to produce those documents before the tribunal, Your Lordship.
When did your uncle die? Do you have
Actually,
the
Philidional Lordship, actually, it should be returned back. This is a
what is the-
drafting mistake of the council, Your
No.
Lordship.
We are asking you what is the date of death of your uncle?
Date of death also not mentioned, Your Lordship. That
Not
should be
mentioned.
mentioned, Your Lordship. It's a drafting fault, Your Lordship.
We don't know. We won't accuse anybody. That person is not before us. We can't accuse.
DW to DW. E2. DW2. This 49. DW2. Yeah, तो माटी का नहीं ना वो भी टेस्ट करना होगा the details itu sih cara beriman langsung क्या beriman langsung
Yes, Lordship. Lordship has marked something. Yes, Lordship. That's the grandmother. Yes. Paragraph 8, Lordship. Yes. Nabjan Mesa. Yes. Yes. That is the grandmother.
No, no, mother.
Mother and yes. 80 years. Aunt came in. For the cross. Not the first. Not appeared, Lordship.
Lordship, page number 54, Your Lordship. Final judgment, appearance. advocate for the opposite party non-appearance on withdrawal, your lordship. Their Okalatma may be withdrawn, your lordship.
Order to that effect in the records, lordship.
Yes.
They withdrew.
That's why
their wakalat.
the witnesses may not be called or notice was not issued to the witnesses, your lordship.
26 order is their lordship.
That's why the DW to not examine, your lordship, I think.
Yes. Very clear order is your lordship, reasoned order. Yes.
It is seen that the petitioner had not produced any other document on which, no, which are annexed to this writ petition. Accordingly, in exercise of certiorari jurisdiction, in view of the mandate laid down in the case of so-and-so versus the Kartan Das. Find that citation, huh? The Kartan Das. Oh, this court would not be entitled to substitute its view on the opinion passed by the learned tribunal. There's no reason for the court to presume that the petitioner was ill-advised during the course of trial. There is nothing on record to show that the withdrawal of the learned counsel for the petitioner, as recorded by order dated 26/2018, was not justified. Resultantly, the petition fails and the same is dismissed. Next panel. Not next panel, same, but the consequences of the opinion dated so-and-so, passed by so-and-so, by so-and-so, it shall follow. Next, but the registry shall send back the records to the learned counsel tribunal along with a copy of this order. So we made a part of record. Second, in this case, notice of motion, the notice of motion was not issued. However, by order dated 28/8/2019, the court proposed to examine the case records. The matter was listed on 30/10/2019, but the matter was adjourned on the prayer made by learned counsel for the petitioner. On 2/2/2026, as no one represented the petitioner, on second call, the matter was adjourned. Accordingly, as the matter has been listed in the motion column after more than 6 years, the matter has been taken up for disposal at the motion stage. The records are available. Next para. The bail granted by order dated 28/8/2019 as an interim measure stand revoked. Which by the registry shall send back the records of the trial tribunal along with a copy of the order to be made a part of the record by the said learned tribunal.
Obligation.
Take a short break and
Item 3.
May I please the last one? The petitioner was already expired on 16 May 2025. They should have obtained the death certificate also.
please tell us what to do.
As per law,
No. Here we'll be asking you to tell us
no,
what to do.
actually, his children may be substituted.
But we can't do it like this. You'll have to file an application.
Yes.
Substitution can't be with this.
Um,
Just take that document. All sides are represented. Ms. J. Paul, learned counsel for the petitioner, has produced a photocopy of the death certificate of the petitioner, namely Nikunja Das. Reflecting that the date of death was 16/5/2025. Stop. Next part, the death certificate is retained on record. Next part, the learned counsel for the petitioner pays for and is granted 2 weeks time to file and appropriate application for you see, as paid for the learned counsel of the matter stands adjourned today for 2 weeks to enable the legal representatives of the petitioner to plead if so advised. This after 2 weeks. Okay, this is a 19 matter, give a fixed date. Instead of 2 weeks, and wait.
By 2030.
Item 5 for motion.
May please, your lordship. Well, the instant PL application has been filed by the present petitioners. And they are the residents of the village Burunga. This is a district of Kasar Milot. Where in the local villages Milot, the respondent number 12 and 13, the Star Cement Milot. They have been setting up a cement factory there, Milot. On the locality of the present petitioners with the densely populated, wherein the Milot, admittedly Milot, there are hospitals, markets, schools, churches, etc. is there, Milot. Then in this regard, the present petitioner from time to time put all the concerned respondents made an RT application, Milot. And one application, District Industries Commerce Center, as well as in the Joint Health Department, they have, in the RT reply, they have submitted that they are not aware of this fact, and no NOC was issued, and it is an admitted agricultural land, Milot. And in this
Where
regard,
is that document?
yes, Milot. Annexure 4, page 28, the RT reply by the DICC. Dated 12/11/2024. Importantly, Milot, paragraph reply 6 and 10.
Page number?
Page 28 to 8, Milot. Sorry, Milot. Para 6 and 10, and rest that simply takes that no available this information.
Where is the question? Where is the question?
Milot?
Where is the query against whom is replies made?
Milot. Milot, yeah.
Where is your query against which replies made?
Yes, my query, your lordship will find, yeah. Milot, page 25, annexure 2.
20?
25.
5.
Yes, Milot. To the Office of the Public Information, District Commissioner Kasar. Then page 27, additional
You give a wrong query to wrong people and then you file a PIL. This, you are giving this RTI to the Deputy Commissioner, District Commissioner.
Milot, District Commissioner forwarded to the concerned DICC at page 27, annexure
No,
3.
what is the difficulty in getting the reports directly from the Pollution Control Board from the authorities? Why you ask authority A to send the
Before
queries to
Pollution
the-
Control Board also we have made RT application.
Where is that?
Yes, Milot. Before Pollution Control Board, lordship will find, Milot, page 29 and 31. 31 our application and 31 is a reply. Annexure 5, Milot.
Now, here you don't give the requirement of pollution control, you say impact assessment.
Yes, it is also here, Milot. Page 35, annexure 9. To the environmental, page 35, Milot. And their reply, page 37.
So you got the impact report, then what?
Then, my lord, one reply, my lord, from the health department, as per our RTI application, page 34, my lord, annexure 8. And our RTI application is page 32, and the reply page 34 by the Joint Director of Health Service.
There is your query.
Page 32, annexure 7.
I could also run that.
No, this is environment. You are asking to Joint Director of Health. What will Joint Director of Health do? And you have not included the pollution control board here. You have
Yeah,
included the executive engineer or something.
My lord, respondent 7 and 11, we have made, my lord.
7 is an officer.
7 is the regional executive in the pollution control.
Remember, they are, you see, they are immune to the action against the state by virtue of their service. Employer, you don't make parties.
Then we will concern department to make him plate, my lord.
No, but this, you see, your nature of information.
Yes, my lord.
It appears that you are trying to extract, this is a PI for what you call other purposes. Why you need the, in a RTI reply, RTI query, why do you need information about members, current designation, previously holding public office? Why you need this? You have some other agenda. Why you need personal information about their offices? This is a public office. A person who is a member of the of any authority is a public servant. Why do you need information like that personal nature?
In the query number 1, we have made it.
No,
Please.
we'll dismiss this. This is something which is not appreciated. You do only what you are required. You need an information about the impact. You ask about that. The personal information for that, we are dismissing this CPIL. You can't ask for personal information. Wait, what post did you hold? Now let us say an officer, district magistrate, he will be holding 20 offices since he's joining in 20 years back. What do you need to do with that information? You don't become a policeman to take out his history. Why you need that information?
My lord, in the lordship, in the
No, these are all
query-
what you call
information about
different
impact
purposes.
assessment, my lord. Though yes, lordship is very much correct. Then committee is not necessary. Lordship true, very. Okay, but in the first, my lord, what is the assessment of that
You
environment?
write to health department about the assessment impact, what they will do about it. Tell us what is the bona fide in your applications. You don't write where you want to. And to the pollution control board, you don't write for the pollution control certificate. You say impact certificate. And they say download it from the download website. Then you don't enclose those things here.
But we have been directed to ask to take the from the download
but it's
website, my
problem in
lord.
your-
But we have we couldn't trace out, my lord. This is not available that record, my lord.
Mr. Baba will help assist you.
Then
In fact, that information is not from the pollution board, it is from the SEA, State Environment Impact Assessment.
State environment.
Yes.
Environment is Mr. Gogoi.
No, I am appearing for 11, SEA.
No, that is that. what is called this?
SEA, yes.
Sia, who's there?
I am appearing.
So in the website, it will be available there.
So that's what he alleges that it could not be downloaded. So let me.
Can you just find out, ask the authorities and
Yes.
something will take it out after some time,
Can it be tomorrow?
tomorrow, okay? But Mr. P.K. Dekar and just give your names, we'll record the presence of yours. So and so for the respondents. Next one. The projection in this rate petition is that the petitioner required a copy of environment impact assessment. What is your prayer here?
Yes, my lord. Our prayer, my lord.
Only show.
At page 19, my lord.
Oh, so this is not your prayer that you want that document.
Directing the respondent to hold an independent inquiry into the matter.
That inquiry is not required.
We have
Whether you have got this copy or not is not not an issue in this writ petition.
we have also made a complaint before the Mirot. The Honorable Minister of Environment and Forest and Climate Change, as well as the concerned Deputy Commissioner, as per number 8, to conduct inquiry into the matter.
Main prayer to
Conduct inquiry.
delays. No, if that is not the prayer, then why would we entertain the writ petition? You have we'll be presuming that you have the impact, and therefore having not got anything, now you are making a prayer here in this writ petition to cause an independent inquiry.
My lord, this is also pillar of our complaint. Complaint at page, Lordship will find at page 39, Annexure 2, 12, my lord. Specific prayer we have made at page 41 in our complaint, my lord.
No, why should the High Court start an inquiry? Please tell us.
But they are sitting silent about the matter, so
You have got the impact report and you are doing nothing about it. You have not highlighted anything which is inconsistent with the setting up of an industry.
and after this complaint, my lord, we have made one reminder to the Deputy Commissioner. my lord.
Then is okay, I can write every day. One person who is otherwise free can write a RTI query every day. Become an RTI activist. But please tell me you got the document and you don't, then after getting the document, you don't say what is wrong in that. Now please tell me, for the petitioner number 1 and 2,
Yes, my lord.
against all the officers in the state, you require their qualification, their what you call their ability. Correct. Now, please tell us about your ability. What are you doing? What is your ability
Yes,
to
please.
understand the impact, environment impact?
My lord, in paragraph 1 and
Tell us,
2.
just tell
Yes,
us.
yes, my lord. Petition number 1, my lord. Both the petitioners belong to the said locality. Petitioner,
That's not the query. You have asked about the
this query, yes, lord.
qualification of all the others, intending to know their qualification to hold that office. Correct.
Yes.
Now we are asking you, having received the impact assessment report, what is your qualification to understand that and why we should entertain this PL for that? Your ability to understand the environment impact report. What do you do? What is your qualifications? What is your degree? What is your educational qualification? Tell us.
I am petitioner number 1, my lord. He is an advocate practicing a bar association in Silchar, and number 2 is a social activist, my lord.
Okay. So they both don't have a qualification to understand the very technical environmental impact report. What is wrong in that environmental impact report?
And
You want an inquiry, you
my
understand?
lord, so far as we got this report, they have asked us to download, my lord. We have stated, speak paragraph 9 has stated, my lord. Paragraph 9, page 13, my lord. From bottom, my lord. 7. Thereafter, the respondent 11 by letter to the change inform the environment impact assessment report, including all the environment aspects, including their expert officers, and same is a big volume. Same may be downloaded by tracking through the Prohibitions 2.2 portal. However, the petitioners tried to download the same but could not trace out the same.
Every state has a different authority.
Pardon,
State environment impact authority, every state has different.
yes, yes.
That's all.
Lawyer, there is a lawyer. Central government.
Huh?
Central government reply is in.
Nah.
This is Parivesh. You just have to type out what you call
Parivesh
this.
portal.
Well,
This
2.0.
the State Environment Impact Assessment Authority website shows this. You open it up and this comes out. Here it is. So that is your qualification to understand scientific report. You can't even open a website.
Hey, put the website.
That's a
Isn't
portal.
it? Show it to him.
Download,
That's a portal.
download karo problem. Could not trace out. Data to tate ওলাইছে.
No, no, no.
This is Parivesh.
উঠিয়াও.
Every state in the country has this.
Prohibitions is a portal.
আমার হেতু good.
So there that application number, proposal number is also given.
2.2.
2.0.2. What is 2.0?
No, you go to the website, it gives a link, you open that up. It just opens up. Whether it is 2 or 3 doesn't matter to you.
The Paris South on that 2.2. Over the Paris South.
If you might application.
Online. But it is 2.0.
Take your proposal. SIA.
The Paris South.
So the state of Assam, we have impact reports of what you call the EC component of 1803, what you call proposals. Each and every is documented. Recommended 1207. Delisted 36, recommended by SCIAA is 1176 AN. Pending for approval is 1, public INA. Rejected is 18. EC granted is 1152. 106 withdrawn.
49730. Public. 2025.
Sorry, this is not bona fide. Your interest is elsewhere. This is a way to threaten the officers who are working in these State Department offices. You want their qualification, you want to make this a, what you call a petition which is equivalent to a writ of, what you call, quo warranto. You want to examine the degree of people who are working. It's not bona fide.
What I say? South now. Page 35.
But then please tell us,
Milord.
you yourself is not very clear. Come to paragraph 15.
Milord.
You say that the petitioners most humbly submit that in respect of the issue in hand, they are not experts in the field of health and environmental issues. With scientific analysis up to what extent of damage is going to be caused in respect of the health and agriculture sector surrounding areas. Correct. So you don't know how to appreciate this. Now please tell us, how would you assist the court in making an in-depth analysis? Have you ever seen an impact assessment report? A report which has caused by havoc in the state. That all this, I'm sorry, I can't, what do you call, my spelling may be, my pronunciation may be wrong. That Gerwamuk impact assessment, all this. Huh?
Gerukamuk.
Those impact assessments, they have been done, there are a lot of agitations going on. Have you seen for this social, these assessment impact reports? Those are positive reports that there will be no environmental damage. But then tell us, how would we do it? How would we assess? It's highly technical. How would you make the assessment? When this was what you call hot news, every time I saw that, we can't read it and understand. It's beyond our apprehension. Not apprehension. the limited knowledge, it doesn't allow us to make assessment of an assessment report.
Well, I just checked it. The whole proposal is there.
Is there?
Is there.
No, it has to be, because you see, we don't have that much of time
I
to spend on finding out this.
have the time while you were deliberating.
Thank you.
Yes.
You show it to Mr. Deka. Mr. Deka, very,
Lord.
Mr. Deka, very, what you call, Official Secrets Act are there.
It was signed by the place of 1973.
Yes, my lord. গোটেইখিনি আছে এতিয়া গোটেইখিনি আছে এতিয়া এই প্ৰপ'জেলটো গোটেই হিষ্ট্ৰী আছে এতিয়া গোটেইখিনি হিষ্ট্ৰী আছে এতিয়া আছে কি নাই আছে চব আছে এতিয়া এইটো ষ্টেটমেণ্ট দিবি Withdraw for you. No, my lord, it is not.
In the central attack from me and the industry coming out in Gauhati. Here is a case where you have a letter to stop the setting of company which was being in Gauhati.
And as per this application with what কেনেকুৱা হৈছে নেকি এনেকুৱা ফেক্টৰী তেনেকুৱা এনেকুৱা হৈছে নেকি নাজানা he's saying not a no
This is a very thoughtfully made out assessment report where every scientific aspects are being examined. And that apart, they have to give the compliance from time to time, whether those points are being complied. If at all in the process of construction of the industry, if at all any of the conditions are faulty, then definitely it will be withdrawn. So those are the conditions. So it is under the scanner of various parameters. And all the guidelines are being guided by the Ministry of Environment and Forest. So we have to follow those guidelines. If at all there is any fault while preparing the Environment Impact Assessment Authority report or the environment clearance, then definitely the petitioner has the right to come and proceed.
Nothing, Manas. I'll just adopt it. But in my case, Manas, just one sentence. The industry is still to be set up, Manas, and there are enough guidelines in place to check all the statutory guidelines and check are complied with.
Page 39, my lord, is a complaint, my lord, before the Minister of Environment.
No, my lord, the industry is still to be set up.
Upcoming.
Grinding, very good to say. Grinding.
Yes.
She is granted a mission.
See that they are secure. I love secret.
Industry to why?
Construction fees.
No, industry, I say,
Grinding unit really good, say, because grinding unit, so, it will, page 20th. Serial number 10, at a reply, yes, yes, sir. My lord, sorry, page 28, annexure 4, my lord, paragraph 4, my lord. So, sorry, paragraph 10, my lord, page 28, in the reply, you said it is a grinding unit located at Burunga, that is grinding unit Star Cements. My lord, page 28, para number 10, I'm reading. Shut up.
set up. Okay, Bono, actually, Solan,
Next start.
start.
Water requirements. In 2024.
Wow.
Actually, Solan, I can it so. Solan,
Query number 10 to port. Page 26.
Yes, Mr. Deka.
Yes, Milot. In our application, Milot, we have specifically made in paragraph 10, paragraph 10 in page 26. Please furnish the information about the detailed project description of the Star Cement industry, including location, water requirement, waste generation. And in the light of this, our query, Milot, they have informed as per the information available through the ICC CASA, it is a grinding unit located at Burunga. They have been, yes, that much only, Milot. But till that, how much development is going on? I'm not, Milot. I have to take instruction, Milot. What the projects progress is going on, Milot.
Heard. Mr. P.K. Dekan on counsel for the petitioners. Also heard counsel for the respondents. Next one. Aggrieved information at the setting up.
Personal interest.
Of an industry under the name of Star Cement Northeast Limited at village Burunga, Burunga, part Roman 2, in the district of Kachar, comma, the petitioners have filed this EIL seeking the following reliefs. Page 18, 19 and 20.
trust grow.
In case of the petitioners is that they are local inhabitants of the concerned village. And the villagers are adversely affected due to illegal setting up of a cement factory, which would be a threat to the health of the local inhabitants and would also affect agriculture and affect the environment. It is also projected that about 5,000 people are residing in the said village, in the vicinity of the cement factory. And there are several government establishments, including railway station, hospital, markets, schools, places of worship, students, hostels, and is highly thickly inhabited. It is also projected that the land was an agricultural land, and ignoring the larger public interest, the cement factory was established in such land. The petitioners have questioned how the respondent numbers 12 and 13 would have obtained or not to proceed in the matter of setting up the cement factory. The next part, the petitioners have filed successive RTI applications before various authorities from 12/9/2024 on 12/9/2024 7 7/3/2024. Then 12/9/2024. 13/2/2025. Twenty-five, 6/2025. To which various authorities had given their RTI reply. The petitioner has made a complaint before the Minister of Environment, Forest and Climate Change, New Delhi, on 29/8 by complaint dated 29/8/2025 against the setting up of the cement plant. Copies of the said complaints have already been submitted before the Ministry of Environment, Government of Assam, and the State Human Rights Commission. The grievance of the petitioner is that the industry is being set up illegally. Said that. It is also projected that the petitioner had, the petitioner number one had approached this court earlier by filing WPC 6811 of 2025. And the learned single judge by order dated 8/12/2025 was of the view that the issue raised in the said litigation was more in the nature of public interest litigation. And accordingly, the petitioner had proposed to withdraw this petition and to file the present PIR. It is also prohibited in this PI that the petitioners have no personal interest in the matter. And they are not guided by the self gain or gain of any person, institution or body. And there was no motive other than public interest litigation, public interest in filing this PIR. Next problem. The learned standing counsel for the State Environment Impact Assessment Authority has submitted that in respect of operation of factory in the state of Assam, which includes a cement factory, there are several. Parameters for and industry operate. Accordingly, it is submitted that the authorities from at any point of time during the operation of the industry would be able to take appropriate steps if there is any violation of the parameters under which what is it called? NEC. What is it called? What is the operating environment clearance certificate? EC. Environment clearance. Within package EC particular is issued. We'll continue at 2. There's some. The last paragraph. The learned standing counsel for the environment department also endorses the same view. Next paragraph. It is observed from the documents annexed to this writ petition that the petition with the petitioner number 1 has filed an application under the RTI Act to several authorities, and that the State Environment Impact Assessment Authority, within bracket, SEIAA, bracket close, SEIAA for short, bracket close, on an RTI application dated 25/6/2025 for information about the Environment Impact Assessment Report. I had provided a reply dated 29/7/2025, had mentioned that the Environment Impact Assessment Report is a big volume, and therefore the petitioner was requested to download the report by tracking online proposal to Parivesh, PARIVESH 2.0 portal. The learned counsel for the petitioner had submitted that the petitioner had made a statement in the petition that he tried to access the said report, but the portal could not be traced out. Stop. On the said submission, the court visited the website and found the Parivesh, PARIVESH 2.0, the Parivesh portal in the website of the SEIAA, Assam. Of the learned standing counsel for the Environment Department has also opened up the said portal, and the Environment Impact Assessment Report could be accessed, which was shown to the learned counsel for the petitioners. Next part. There is no doubt that the Environment Impact Assessment Report is available in public domain in the website of the portal of SEIAA. It was expected of the petitioners to make their own assessment of the environmental damage which the area would suffer due to functioning of the said industry. However, without making their own effort, the petitioner in paragraph A of the in prayer A of this petition of this PIN has requested for holding an independent inquiry into the matter, and if satisfied, close down the cement factory. Full stop. In the considered opinion of the court, as the Environment Impact Assessment Report is available in the web portal disclosed by the SEIAA. It was for the petitioner to project as to how the sorry, not how, why this said environment impact assessment report should not be accepted as correct projection of the environment aspect of the locality where the industry is set up. First off. Accordingly, it is the considered opinion of the court that this court would refrain from making inquiry the they can call of the petitioners who could have accessed the report and informed the court about the adverse environment impact, so having elected not to do so. To make an inquiry at their behest. Full stop. Next. From the statements made in paragraph. Hmm. 4 and 10 of the writ petition. It appears that the industry against which complaint is being made has already been set up. First of the petitioner claims that the factory was illegally constructed. First of strangely, alleging illegal construction, the petitioner has filed a complaint before the Assam Human Rights Commission. The authorities who had given the construction permission have not been moved to project that the construction permission was illegally granted. Full stop. Therefore, next paragraph, as there's no material in a court to arrive at a finding that the Pollution Control Board, Assam, or the Industries Department, for the government of Assam, including the Commissioner of Industries and Commerce, cannot take an appropriate steps if the industry set up by the setting of the industries complained of does not comply with the requirements of the Pollution Control Board. Full stop. There is no material in the petition to presume that the setting of the industry has caused has impacted the environment in any manner, or it has caused pollution which is higher than the norms prescribed by the Pollution Control Board, Assam. The court does not find any reason to issue notice in this year. Accordingly, no grounds have been set up by the petitioner by which it can be presumed that the concerned cement factory, sorry, Star Cement North East India Limited factory has caused any damage to the environment due to pollution or otherwise operation of the factory. This case stands dismissed at the motion stage without issuance or notice of the respondents. It shall be no less to cost. Please give us slip of your recording your presence. We have given.
Item 31.
Not they will wait for some time.
He's coming, he's on.
Lordship, after something, it's actually code number 9, Lordship.
Lordship, in the meantime, I can give a brief background of the PI, Lordship.
Let him be there. Otherwise,
Yeah, I take some time to just give.
no, because we are taking up the matter despite a prayer for adjournment. That's why.
He will come, Lordship, he will come.
It's okay.
He will come.
We understand. He has come.
I spoke to the concerned person who is dealing with this portal and all, my lord. So he informed me that for the next session, they are going to issue a circular. How it will proceed, my lord, regarding admission and all. And apart from online, offline mode is also available, my lord. Because
Public must be informed.
yes, my lord.
You see, we are looking at children who are underprivileged.
Yes, my lord.
Who don't have access to
Yes,
the
my lord.
modern amenities.
That is why, my lord, offline.
Therefore, who will inform them at the village level? I think you'll have to activate some sort of
Yes, my lord.
information.
For that purpose, they will issue a circular, my lord.
No, we request you that you please examine that whether you can rope in this booth level workers of various political parties, also involve this, what you call the District Legal Services Authority.
Yes.
Because you'll have to provide them some material so that they can distribute.
Yes.
Otherwise, this people who are less privileged, they will not know, they will miss out their season.
Yes, information has to go, my lord.
Yes. So when is the admissions due for schools?
For
Normally
next session, my lord, it will start from March.
Start from March.
End of March, my lord.
So end of March. So therefore,
Lordship, it will start.
15th of March.
Month of March, Lordship. Some schools have already started taking admissions.
taking admissions.
Yes, Lordship.
So you'll have to immediately first take steps to inform all the schools that this RT, what you call the admissions under the RTA Act must be adhered to. Can we take it up next week by the time you inform us?
Yes, madam.
Lordship,
ma'am.
kindly come to the activity calendar. Lordship, they have prescribed it
Where?
themselves in the OM at page 43, Lordship.
43.
At page 43, clause 7, Lordship. Lordship will Uploading
Yes.
information, that is 7, Lordship, serial 7. Uploading information of children in software by schools. Approval of children taken, admitted by the district committee. Lordship, in fact, after we came to this court, by orders of this court, they had issued notification to the various districts and the district level education officers to make it mandatory for the schools. And the schools had to put it on the notice board as well as on the website. So in the absence of the website of the school and the state portal, Lordship, this has not been implemented at all anywhere. When we check the website of the schools of the non-aided private schools, Lordship, only 2 schools we found. One was faculty school, one was Sanskriti Gurukul, which had put up this information that they had 25% seats available. None of these schools had put up on their websites also, because schools have their own websites where they have to put in the vacancy of 25% of seats, Lordship. So after this PL, those notices also went out by orders of this court, Lordship. Lordship, I can just going back a little bit, Lordship, if Lordship takes up the last order, Lordship. Lordship, how everything has changed over a period of time, right from giving assurance before this court that the online web portal is ready, and all of a sudden the web portal is there, but instead of non-aided private schools, only vernacular schools have come forward, and that's with some cabinet decision, Lordship. The affidavit filed by the respondents, Lordship, on
Something
18
same like us. When we had to
Lordship made
after the admission is over, then they'll put it up. Don't worry. Mr. Karunia, yes?
He's aware of it, Lordship. Lordship, I'll bring Lordship to their affidavit filed on 18/6/2025, Lordship.
Affidavit. Yes.
Lordship, paragraph 2,
Affidavit filed by
Mr. Lordship.
name, respondent number.
Affidavit filed on behalf of the respondents as per order dated 23/5/2025.
Which respondent we have?
Page
17 affidavits here. That's why you are asking.
page 359, madam.
359.
359, 360, yeah. Shahnawaz on. Paragraph 2, Lordship.
359.
का कितना पेज होगा फिर
This is
400.
478.
359.
I am at 360, Lordship, the next page.
360.
Yes, Lordship, paragraph
That-
2.
No. 360 is South Point School.
Lordship, there must be. Lordship can have this affidavit from us, Lordship.
Just tell the affidavit by whom?
Shahnawaz Chaudhary, madam.
No. In my index, we don't have that Shahnawaz. We have respondent numbers.
Your respondent number.
Here, madam, in this affidavit, it is mentioned as on behalf of respondents.
Let's pass it on.
Yes.
Continue.
Is it filed on 18/6/25?
Yes, Lordship.
18/6/25.
6/25.
Yes, madam.
Okay, that is 456 in our record.
I had to have page number 2, please.
उसके साथ मिला लो एक दिन सब पेज नंबर.
456.
Yes, Lordship. 456. Oh, we'll have to carry it.
Yes, we got it.
Paragraph 2, Lordship, that it is stated that in compliance of the order dated 25/2/24 of the Honorable Court, the online portal for implementation of the Section 12(1)(e) of the RT Act was made operational, and as per the decision taken by the Cabinet, all vernacular, medium, unaided and non-minority private schools of Assam were instructed to register themselves in this dedicated portal by clicking on so-and-so link, effective implementation of the Section 12(1)(c). Lordship, there is just one thing, was instructed to register themselves. So if none of these schools have registered today, till date, only 9 schools have registered, it is their own statement in this affidavit. And even all vernacular, medium, unaided and non-minority, Lordship. White so-and-so an office OM was issued that clearly outlined the important aspects on the online portal for implementation of the Section 12(1)(c) of the Right of Education 2009. It was notified that during the registration of schools in the said portal, the schools should have complied with the legibility provisions for recognition, permission of the school under the Assam Right of Children to Free and Compulsory Education Rules 2011, the Assam Non-Governmental Educational Institutions, so-and-so, the Assam Non-Governmental Educational Institutions Rules 2020, and shall mandatorily have UDISC, Unified District Information System Education Code and Number. Further,
Mr. Khatuniya,
Yes, madam.
you see, if you exclude this, if it is inclusive only of vernacular medium schools,
Yes, madam.
is there any private school giving vernacular education?
Yes, madam.
there
Which
are
one?
few, Lordship.
Which
One,
one?
Jatiya
Jatiya
Vidyalaya.
Vidyalaya, Sankodev Sikhu Niketan, there are a lot of schools.
Now, Lordship, let me finish this affidavit, Lordship. On my response, we have given a complete justification to why this is not correct, Lordship. From a guideline, white so-and-so issued from Dispur was issued, which broadly mentioned the workflow process for registration of vernacular medium, unaided, non-minority private schools, as well as process for registration of students in the portal within the timeline framed. They have outlined the guidelines, but this is only for the vernacular medium, Lordship, because for unaided private schools, there already exists an OM. So, Lordship, after that, I may bring Lordship, they have just put in about everything about the vernacular part, which is not there, which is not our prayer, not part of my PI, Lordship. So our reply, Lordship, we have filed, I don't know what page number it would be there, Lordship, but we have filed it on
Last date.
25/6.
This is the last date. Yes,
December.
That would be page
11th of
466.
December. 11th of December.
466.
No, tar agotata mi disu.
466.
2023/5/2025, Lordship, where we have stated after going through the website, how we have found that only 9 schools had been had registered themselves in the website, Lordship. Lordship, we had filed an affidavit on 24/6/2025, Lordship. Reply to their affidavit, Lordship. They had filed as per the orders of this court, Lordship. They had filed an affidavit, and we had also filed one, Lordship. On 24/6/2025, has Lordship found it, Lordship?
Yes, 466.
Yes, may I read it, Lordship?
Yes.
We were also asked to file while we were objecting to the respondent's affidavit, Lordship. That the affidavit filed by the respondents demonstrates no real or meaningful compliance with the repeated directions of this honorable court concerning the implementation of 12(1)(c). As per paragraph 2 of the affidavit, respondents have restricted implementation of section 12(1)(c) to only unaided, non-minority, vernacular medium private schools, thereby unlawfully excluding all English medium schools. That such exclusion of English medium schools is arbitrary, illegal, and in gross violation of the RT Act, the binding guidelines of the National Commission for Protection of Child Rights and the unequivocal directions of this Honorable Court and the Honorable Supreme Court. That a bare reading of 12(1)(c) of the RT Act, when read with Section 2(n), reveals that the mandate of reserving a minimum of 25% seats for children from economically weaker sections and disadvantaged groups is applicable to all unaided and specified category schools without any classification based on the medium of instruction. There is no statutory basis to restrict the application of this provision to only vernacular medium institutions. That this Honorable Court, through various orders in the present matter dated 12/4/23, 17/5/23, 24/5/23, 9/5/24, and in earlier proceedings in another PI lordship which we have filed, has consistently directed the respondents to ensure comprehensive and faithful implementation of Section 12(1)(c). Furthermore, as recorded in paragraph 7 of the order dated 2/4/24, the Standing Council of the Education Department himself submitted that admissions under 12(1)(c) in unaided, non-minority private schools were ongoing, a submission that would include all such schools regardless of medium of instruction. That contrary to these submissions and court directions, the OM referred to in the affidavit seeks to limit the scope of the law, thereby misleading this Honorable Court and creating a false impression of compliance. Such actions amount to a breach of the assurances made before this court. Then, Lordship, that by order dated 9/9/2024, the Honorable Court had further directed that the admission portal for implementation of Section 12(1)(c) can be created in conformity with the standard operating procedure issued by the NCPCR. The said SOP dated 25/6/2021, which was also endorsed by the Honorable Supreme Court in Children in Street Situations, order dated so-and-so, does not distinguish between English and vernacular medium schools. The exclusion of English medium schools is therefore in direct contravention of the SOP and binding judicial directions. Thus, the law on the point is well settled through the judgment of the Honorable Supreme Court in Society for Unaided Private Schools of Rajasthan versus Union of India, which has held.
This would go against your argument. The reason is, in this judgment, there's a paragraph which says that it will be only those schools who receive aid.
Sorry, Lordship.
In this judgment, this was by a division bench. Here it was laid down in one of the paragraphs that only aided schools and not those schools who are private institutions and do not get aid from the government would be compelled under the Act.
So our prayer is that unaided schools, Lordship, the schools which do not receive any aid from the government.
Then this judgment against you will show you that.
Lordship, the OM itself starts with Lordship.
No, we don't know, but now, since you have said that, 2012 6 SSC page 1. 2012 6 SSC page 1.
I'm relying on the judgment because nowhere it says that the exclusion of schools should be based on the medium of instruction, Lordship.
That too, what was that? Just show you.
जजमेंट है हमारे पास वही वाला है ना
You see, an issue arose.
Yes, Lordship.
An issue arose where I think Ms. Ghosh will be also affected. She was affected at one point of time. I'm not saying it stays where it is. A certain child was suffering from a disability. A newborn child was having some disability, and a PI was filed, and some hospital was asked to take care of that child. But that is non-aided charitable hospital, and this child, because of interim orders of the court, had to be, he's still, I think, under treatment by a private hospital.
Yes. But land is been given by the government.
Yes.
So whatever be, but still that the land maybe, you see, it's for infrastructure. That doesn't make it 8. For the purpose of infrastructure, the government has the liberty to give land to someone. It doesn't mean that it's a 8. For 8, you'll have to say that it's in form of an 8. Otherwise, there's no presumption of 8. You see, for example, somebody, a lawyer comes and goes to the High Court library, enters it, STC, I want to give it to the library. Has the library of the Gauhati High Court sought for an 8? No. But somebody is offering something that would not necessarily be an 8. That may be for the welfare of the advocates. But you can't say that this was an 8 to the institution. So that's the determining factor. 50, come on, 55 onwards.
Lordship, I think is referring to 9.2, Lordship.
No,
Damien,
I don't
9.2.
know. Because
9.2 says Lordship.
no, just I'll come to it. Para 50, 55, 67. Just a moment. Just
They can get reimbursement from the government. As per the law. You will get it from the government. We don't know what it means.
Down. Pathology.
so heading removal of obstacles. Come down.
No, it's not this. This is.
Rajasthan वाला नहीं
No, this is not Rajasthan.
ये तो NCP से है.
He's teaching them.
Just come down. No, before that. Then go up. You go up. Oh, just on. But there's a heading called removal of obstacles. Just come down again. Removal of obstacles. Just go. Just go. Just come down. Down again. No, this is not matching. I'll give you this. Please read this once. I have a habit of reading it from here. SCC doesn't match. Because what SCC does is that the view of the judge of the senior judge would come up. So therefore, the paragraph is not matching. 57.
But we'll look at the alag hai na.
We just examine that aspect.
Lordship,
But this is-
we have referred to this only to the instruction of medium.
No, we understand. The fact is not with regard to the medium, but if it is an unaided school, and if it is for, if this is, if what we are reading is correct way of reading it.
As a whole, Lordship, on the judgment, we have gone through, but we find nowhere any of the judgment says, there are so many judgments that you make a difference between registration of schools from vernacular to English. It is just unaided private minority schools, nothing else, Lordship. Not minority schools.
Minority is excluded.
Excluded, Lordship.
Unless it is shown in view of this judgment that they receive substantial aid from the government. If there is an aid from the government for a minority school, then they are covered. This is that judgment.
But we are not on that, Lordship. We are on unaided schools, completely on unaided schools.
Just note this and find out from the SCC volume and then.
We will look into that also, Lordship. So, Lordship, after this, Lordship, my paragraph 10, if Lordship comes to, only after that we went into the website because in their affidavit they had stated that the website was operational. So, when we went into the website, Lordship, we found only 9 schools across the state out of more than 10,000 schools in the state of Assam. Only 9 schools had registered, and in the drop-down list, we had only 9 schools. So that is when we gave that.
I'll tell you why we have stopped here. Is the reason is that in this judgment, there is a dissenting judgment.
Yes.
And the dissenting, honorable dissenting judge, expressing dissenting opinion, has said that it is covered. You see, therefore, it's a dissenting view that it is covered. But otherwise, the majority judgment is that it is not covered. So that's why, that is the reason why we are asking you to examine this and then address us.
And Lordship, on the unaided aided side, we are not on that at all because their office OM itself starts. If Lordship comes to page 39, Lordship, the first general instruction part A says, can I draw Lordship's attention to page 39 of my writ petition, Lordship, of my PI, Lordship.
Yes.
Part A, General Information, Lordship, in pursuance of the provisions of Section 12(1)(c)(2)(3) of RT Act 2009 and Rule 7 and 8 of State Rules of Assam, right of children to free and compulsory education, all the unaided.
Statements they do.
Said not receiving any government money.
Yes, Bhatna, you have a valid point insofar as the aided schools are concerned.
Yes, Lordship.
There is no provision anywhere which excludes medium of, which has an exclusion by medium of instruction.
That is the main crux today, Lordship, because something absolutely which was not there has been brought into this OM, Lordship.
Therefore, restricted rights to children to free education.
The Lordship, now we say the world is progressing, children should know English. Why do we have to put them back to vernacular? Lordship, vernacular can be learned. It cannot be made mandatory, Lordship, especially for for these people. Then Lordship, we shouldn't have these things on paper. We have them on paper and we keep changing them as and when, Lordship, to our convenience. Yes, Lordship. No, but in some states, Lordship, they have extended this same provision up to class 12. Because a child who is married, Kerala has done it, Rajasthan has done it, Lordship. And here today, we are still fighting for a website. We are still asking, please come up with a central portal, come up with the registration, come up with the vacancies in the website.
Kerala has come in the first state in the country to come with regulations.
Yes, my lord. Yes. That is not the case otherwise, my lord. Because, my lord, no, my lord, otherwise that is not the case because they will obviously, the word neighborhood is mentioned in the 12(1)(c), my lord. Maybe, my lord, that may be a technical glitch, my lord, but or in fact, my lord, that information has to be filled up by the school. Maybe while they input the information, then they select the district wrongly, my lord. Yes. Yes, my lord.
Neighborhood school.
Neighborhood. In the neighborhood.
So page.
No.
And Lordship, it has to be mandatory. Every time everything comes out, it has to go to the website. Now they say that the schools were not informed. The last date it was informed that the schools were not informed to register. If they do not register, how will the public know, Lordship, that there are vacancies in these schools? Only 12(1)(c), nothing else, Lordship. That is 25% of the admissions in the schools. And that too from class, somewhere it is class 1, somewhere it's class nursery, up to class 8.
No, it's class 1 only, my lord.
Entry class is not there, but here they have presumed it, Lordship. 8 years. 8 years. No, class 8.
Class 1, my lord.
No, Lordship, class 8. 1 to 8, Lordship.
1 to
No, no, one, only one.
In compulsory education is
No,
Only one. আপনি এখনো চাপ-
no, no, that class one.
In-
Admission into class 1, 2.
Only one, my lord. One, my lord. That's label it is free education up to class 8, my lord.
Yes,
But-
Lordship,
but-
that's what.
But C is applicable to admit in class 1 only. Yes.
The primary part, Lordship.
A prayer for adjournment was made by made on behalf of the School Education Department. Stop. However, comma, as this PIL deals with,
Madam, I'm sorry to interrupt. Prayer for adjournment is not behalf on the education department, my lord.
then
Lordship, we had sought for an adjournment.
petition,
Lordship.
petition, I'm sorry. By the petitioner, Gustav, however, comma, as the issue raised is concerns extent of schools' responsibility for free and compulsory education within the scope and ambit of section 12 within bracket numerical 1 bracket close small a, so small c of the Right of Children to Free and Compulsory Education Act, 2009, the court has taken up the matter. Next para. The petitioner in person, by referring to the contents of the office memorandum bearing number capital PMA 73/2021/47 dated 2/9/2021 has submitted that contrary to the provisions of the Right of Children to Free and Compulsory Education Act, 2009, admission to unprivileged children falling within the meaning of who are entitled to free education, the admission is restricted only to, where is this vernacular in this OM?
It is not here, Lordship. This
Then-
has subsequently been brought in.
Okay.
In the affidavit, Lordship, which I just read out, Lordship.
Referring to the OM, that is mentioned, how it has been said,
By a cabinet decision, they have brought in
they
affidavit
said
filed on
OM.
18/6.
does not restrict admission to children having right to free and compulsory education on account of language of instructions, however, by way of an affidavit.
Filed on 18/6/2025, Lordship.
Filed on filed by the Secretary, Elementary Education Assam on 18/6/2025.
So page 364, OM, office memorandum, ये वाला बंद हो गया। And it's right.
Admission to those children were restricted to schools imparting vernacular medium education. Full stop. It is also submitted.
Lordship, it's part of the affidavit, Lordship, that OM is part of the affidavit.
So, next, moreover, comma, it is submitted that the petitioner in person, comma, on visiting the website of the state of Assam has found that the dedicated portal of https colon /RTE small dash SSA .assam.gov.in does not show all schools, all aided schools to be registered under the portal.
Indeed.
Full stop. It is submitted that the portal does not give the appropriate information with regard to the seats available for admission, which is 25% under the Right of Children to Free and Compulsory Education Act, 2009. But accordingly, it is submitted that owing to lack of transparency, it will be very difficult for unprivileged children for whom the said act is meant to have themselves for the parents of the unprivileged children for whom the free education is envisaged, to have their wards admitted in such aided schools. It is submitted that as per section 2 within bracket N of the said 2009 Act, a minimum 25% seats are required to be reserved for children from economically weaker sections and disadvantaged groups. Next paragraph. At this stage, the Learned Standing Council for the School Education Department has ruled that he has spoken to the concerned authority who is looking after the web portal, and it is submitted that he would obtain instructions and present the instructions regarding to the operation of the portal to the court. Next paragraph. Having observed that the next admission season may commence in the month of March 2026. The court is of the considered opinion that by the time the admissions, the schools would commence for the academic session 2026-27 for class 1, the state should make an endeavor to see that the portal is made operational. To stop. The authorities in the school education department shall also apprise the court as to whether mandatory instructions have been issued to all the aided schools who fall within the scope and ambit of the Right of Children to Free and Compulsory Education Act from 2009, who have compulsorily registered themselves in the said web portal, and whether all the informations and whether the directions have been issued to all such schools to divulge all the appropriate information in the web portal. Next para. The court hopes and trusts that in the event such directions have not yet been issued, the school education department shall do the needful as is required under the Right of Children to Free and Compulsory Education Act of 2009 and the state rules framed thereunder, and to ensure that the said act and rules framed thereunder are scrupulously followed. Full stop. On the next date of listing, the court may want to look into the website for which the school education department shall provide a person to assist the learned standing counsel for the school education department to enable the court to navigate through the website. Full stop. Next panel. List on a week's time.
Yes, madam.
Give us a date.
19th, madam. 19th or
19 to
20 till 20. Lordship, after the 20th. After 20th of Feb, Lordship.
then 23rd?
Huh?
23rd?
23rd. Lordship, while dictating, Lordship has been mentioning aided. These are all unaided schools, Lordship.
unaided.
Unaided, Lordship.
2 and C is unaided.
Yes, Lordship, it's unaided.
Achha, unaided, not aided. Unaided.
Twice or thrice I heard aided, Lordship.
Yes,
That may be
yes.
correct.
Yes, yes. Correct. You have used unaided 3 times.
23rd, Lordship.
Saturday would be more free. 21st, no.
He is not coming.
No. Okay.
Lordship
23.
will,
23.
23rd, Lordship.
23.
Much obliged, Lordship.
Obliged, madam. Yes, madam. Yes, madam. Obliged, madam. Yes. Judgment is. I'll find it out. Obliged, madam.
Item 6 for motion.
May it please your lordship. I am representing on behalf of petitioner, your lordship. I am a social worker, your lordship, and a former student leader.
Yes, please proceed.
Yeah. My lord, this is a public interest litigation challenging the constitutional validity of the Assam Private University Amendment Act 2025, Your Lordship. My lord, this act is not mere regulatory, it is a prohibitory. It imposed a blanket ban on all the technical, medical, and agricultural courses in private universities starting 1st April of 2025, Your Lordship. I'm here not from the side of the university owners, but for the 2 lakh students in Assam who are, as per reports, are facing a severe shortage of higher education seats.
Which provision
This,
you are referring to?
I'm most preferring on 4 provisions of the amended Act, Your Lordship, particularly the amended Act of Section 4, insertions of Section 10A, and amendment of Section 44. May I refer to, I have already enclosed the Amendment Act, Your Lordship, some private university amendment act.
What will happen? What will happen if security clearance is wanted? How will you
I
be
will come
affected by that?
Yes, Your Lordship. Your Lordship, Your Lordship is referring to Section 4, Your Lordship, of the amended Act, Your Lordship.
Yes, you must understand that we have read it. That's why we are asking you a question. How would
Yes,
you
yes.
be aggrieved? How would you be aggrieved if
I
the
will come
authorities
directly
want security clearance of people?
Yes, obviously, Your Lordship, I will come directly to this. My Lord, Section 4 and Section 10A1 introduce vague concepts like antecedents and precedents for security clearance and activities related to conviction, Your Lordship. Here comes 2 core issue which need to be defined first, Your
No,
Lordship.
please be practical. You see what has happened in one of the states in the country. You have seen that.
Yes, Your Lordship.
A bomb blast took place. There
Maybe
was an
Your Lordship.
indication in the newspapers about radicalization of the institution.
Your
Correct.
Lordship,
You want to
this
take
is
responsibility, you
one.
can deposit some amount if any activity takes place within this time here you. Within that time, something takes place. An unwanted character becomes the director of medical education in some school and colleges. Are you prepared to give us some security in form of money?
No, Your Lordship. I'm coming directly to the undefined provision, Your Lordship. There's only need to be clarified from the authority, Your Lordship.
Yes.
In 2 issues, Your Lordship, I may be allowed to highlight those issues, Your Lordship.
Yes.
Actually, the antecedents is not been defined in whether even the traffic violation count as a bad antecedents or not. It has to be what kind of antecedent has to be count in this particular provision has to be defined thoroughly or expressly provided, Your Lordship. Thus, teaching comparative theological count as an activity related to be convictions or these are the issues need to be clarified and apex court already been decided in this matter also, Your Lordship. In uh, Syria's Singhal case, it has been the vagueness confer unguided power and executive in the case of sealing effects of academic freedom, Your Lordship. It has only been decided and that this particular precedence has not yet been challenged by not yet been challenged by any of the party till that, yours.
Look, please tell us what is wrong in this. Which paragraph, which insertion of which section you are aggrieved?
I'm referring to the Section 4 and holistically with Section 10A1 of the implement, Your Lordship.
Yes, university shall not involve in any activity relating to conversion of any student, faculty, and other staff. You are agreed by that?
No. Actually, when it has to be expressly defined. Now it is very vague, Your Lordship. And particularly, I'm now referring to the.
What is your name, Mr. Counsel?
Jaswanta, Your Lordship. Jaswanta, Your Lordship.
Jaswanta. Mr. Singh, now please tell us under which law we will presume that the act of a legislature is vague. which is the authority on the point that there is a presumption against a legislature that it is vague.
Your Lordship, on superficial reading of this particular provision, it is not defined, so it is not provided.
Wisdom of the legislature. It says that we want to have a background check, security clearance, and that the university shall not indulge in what you call this conversions. What is so bad about it?
I'm not objecting those.
In a medical college, you want medical education or you want conversion classes?
No. Your Lordship, I'm not against this the essence of the provisions. Your
Then please
Lordship.
tell us where you are aggrieved, Mr. Singh. Please tell us. Be very specific.
Your Lordship, even the teacher on comparative theological count as an activity related to the conversion is the main issue, Your Lordship. Sometimes.
No, if you want, you see, please give us a specific affidavit that what you want in a medical education is a conversion classes. Be very specific. Write it down. What prevents you from writing it down?
Your Lordship.
We record your undertaking that within a week you will file an undertaking that you want.
Your Lordship. And other provisions also, sir. Regarding this issue, I will file the affidavit, Your Lordship.
Affidavit saying that you want conversion classes also.
No. No. I'm not against this provision, Your Lordship. Actually, I just need to clarify certain vagueness of this particular provision.
Let me state the vague. How you are agreed by vague statements?
Particularly in the section 4 antecedents.
You see, Mr. Singh, you are making a vague statement that this is vague. You don't say what is vague in that. How that vagueness has to be filled up, that you don't say. Your submission is as vague as that act. I won't say the act to be incorrect. I won't say your submission to be incorrect. You see, in a division bench, we are taking up the legality of the act. You have to be more specific as to which particular provision is offending. What is an omission? The first question would always be, can an omission or a mistake or a vagueness in the statute be presumed by the court? There is a presumption that the act of the legislature is self-contained. It has everything. If there is some omission, that is an omission which is willful. The act wants it that way. The legislature wants it that way. They are not one. There are many authorities which say that there is a presumption of the correctness of the legislature. So you are arguing what is already laid down in the decisions of the Supreme Court, which we have followed.
Your Lordship, may I come to section 10A2, Your Lordship?
A2. University shall not open any new technical, medical, so and so. Because this medical seats, technical seats, are not fixed by the universities. They are fixed by the UGC. It is for the UGC to extend the number of seats.
Arbitrariness, Your Lordship. Section 10A2 of Infinity.
10A2, we are there only, medical seats. Can a medical seat university be empowered to to extend seats in medical education?
No, Your Lordship, in the 10A, I will.
10A2 is there at page 35.
Here, Your Lordship,
Mr. Sharma, are we incorrect? It's the UGC who gives the seat allotment.
MCI in case of
MCI in case of
in case of
medical, it is
medical,
MCI.
MCI, I'm sorry, MCI, yes.
Your Lordship,
Ultimate regulating authority is the UGC.
UGC and technical IICT is a regulating authority also.
You see, Mr. Singh, there are not one case, but there are at least 3 cases which I know of where because of the admissions already taken in view of the what you call certain anomalies, ultimately in one case the Supreme Court said that they will be given their degrees. In one case it has been turned down that the extra admissions would not entitle a person to become a qualified personnel. So
Odisha Leave
if,
Corporation.
huh?
Odisha Leave Corporation.
Odisha Leave Corporation, yes.
Even Lordship in the recent, in the Rajasthan cases, Lordship, Honorable Supreme Court imposed Lordship 50 lakhs each,
50 lakh
50
cost
lakh each to the
each
Lordship,
to the
200
institution.
colleges Lordship.
That's why I said, you deposit money with us. Let the education be like that, and every student will
Slokas also
be
not
paid
clear.
compensation.
Your Lordship,
We don't find any.
Slokas is also not being stated.
Locus we omit for the time being. He's raising a public issue. We accept it for the time being.
Your Lordship, this Imprint Act itself prohibits the university from opening new courses in medical, engineering, and agriculture, Your Lordship.
You want to do it?
No, Your Lordship. I have annexed a news report, Your Lord, in page number.
We are not on that, Mr. Singh. We are asking you, do you want any college to impart education to which it is not authorized? Is that the PL for that?
No, Your Lordship, I'm coming
What
from
do you
the
need,
part
Mr.
of the
Singh?
lawsuit which
Please tell us, what do you want? Please tell us, what do you want?
Your Lordship, the previous act itself do the needful, Your Lordship. This act itself is prohibiting the central act, Your Lordship. It's a central act, especially Your
Why
Lordship.
can we take it from you that the petitioner's intention is that the university will open technical medical education without authority of law? That's what you want?
No, Your Lordship. Then the previous.
Then what is wrong with this sentence? What is wrong with this new insertion of 10A?
Your Lordship, it is in violations of the National Medical Commission Act 2019, particularly Section 28 and 29, Your Lordship.
Does it say that the university will be empowered to run classes?
No, it's a sole authority to grant permission of the new medical colleges, Your Lordship.
That's why it says private university cannot. Correct? What is wrong in this act? I'm sorry, it's a waste of time.
No, Your Lordship. Even the AICT Act 1987 empowers the technical college to approve, Your Lordship.
And you're equating with that with the new seats, with new courses.
Yes, Your Lordship.
Now tell us, how much cost will you impose?
Every year, more than 2 lakh students has been dropped
No, we are
off.
on cost. We are on cost. If that is your view, then please tell us in PIL how much cost should we impose?
Yeah, this application is filed on behalf of the student only, Your Lordship.
We are sorry. Heard Mr. P. Jaswanta Singh, learned counsel, who has appeared for the petitioner online. Full stop. By filing this writ petition in the nature of PIL, the petitioner projects that this PIL is compliant to the Gauhati High Court rules for PIL. Full stop. Next paragraph. The petitioner has assailed the notification dated 26/2025, by virtue of which the state has notified the Assam Private Universities within bracket amendment bracket close Act, 2025, by virtue of which the following provisions of the Assam Private Universities Act, 2007 has been amended. Full stop. The said provisions are amendment of section 4 by insertion of clause D of section 4, comma, insertion of section 10A after section 10 with subsection 1 and 2 thereto. Full stop. Amendment of section 44 by insertion of subrule 4 after subsection 3. Full stop. The text of the said act is reproduced herein below for the sake of convenience. Page 3435. Next paragraph. The learned counsel for the petitioner has submitted that the provisions which have been inserted by way of an amendment are very vague, and therefore the said amended provisions require more clarity from the competent authorities. Full stop. It is submitted that the requirement of security clearance in respect of the antecedents or precedents of the sponsoring body is wholly unjustified. Full stop. It is submitted that there cannot be restrictions on the university to involve in any other act which may be deemed necessary. To stop. In this regard, it may be stated that the restrictions sought to be imposed by newly inserted section 10, capital A within bracket 1, is to the effect that the university shall not involve in any activity relating to conversion of any of students, comma, faculties and other staff, comma, further requiring that the university shall maintain a secular character. Full stop. Subsection 2 of section 10A provides that the university shall not open any new technical, comma, medical, comma, para-medical, comma, nursing and other technical courses related to agriculture, comma, veterinary, comma, dairy and other allied subjects with effect from 1/4/2025. And subsection 4 of section 44 provides for inspection of the university by the state government once in 3 years. Full stop. On a specific query of the court, comma, the learned counsel for the petitioner has submitted that it is not the case of the petitioner that there should be a course in any university relating to conversion of students, faculties and other staff, or that secular character should not be maintained. Full stop. It is further submitted that it is also submitted that insofar as the new technical courses are concerned, comma, what did you say, AICTE permits? Mr. Singh?
Yes, Your Lordship. AICTE and National Medical
The
Commission.
AICTE Act permits any private university to start such course as is permissible under the said act. Full stop. And how you are aggrieved by the inspection clause? You are not aggrieved. Inspection of universities, are you aggrieved by that also? 4. Section 4 of the amending act.
Pardon.
Page 35 of your writ petition,
Yes, yes, Your Worship.
section 4, are you agreed by that also? No.
Your Worship is beg, Your Worship, antecedents and the precedents.
I understand, but what do you want? There should be inspection or there should not be any inspection?
There should be instructions, sir, Your Worship.
Okay. Stop. In respect of amendment to subsection 4 of section 44, it is submitted that the petitioner has no grievance with the inspection being carried out of a private university. Stop. However, it is submitted that the clause is absolutely vague. Next paragraph. Per contra, the learned standing counsel for the UGC has submitted that he questions the locus standi of the petitioner to file and maintain this PIL. Stop. It is further submitted that the authority to allot seats for medical, paramedical, nursing, and other technical courses are the respective authority, like MCI, the Medical Council of India, next, what is that, Mr. Chama? Medical Council, Engineering, who does it?
AICTE, All India Council for Technical Education.
AIC, All India Council for Technical Education, within bracket AITC for short, and other prescribed authorities. Stop. Accordingly, it is submitted that it is not open to the private universities to increase seats in various technical courses without the approval or sanction by the competent authority. Next paragraph. The court is of the considered opinion that it is not open for the court to presume that the act of state legislature is vague. Full stop. Despite giving sufficient opportunity to the petitioner to point out as to what was the vague clause in the amending act, no specific submissions had been made with regard to the nature of vagueness. Full stop. As already stated herein before, no, not stated. Next paragraph. If we refer to the current incidents, the recent incident which happened in one part of the country where there was a bomb blast which was attributed to particular educational institutions with media allegations of radicalization of persons within that institution, the court cannot be oblivious of the fact that at the present crossroads, it is very essential for the state to examine the security clearance with regard to the antecedents or precedents of the sponsoring body from the Home and Political Department, Government of Assam. Full stop. In the Northeast, there are various religions, tribes, and communities who are residing together, making a unique fabric of citizens residing in this part of the country. Therefore, if the state deems it appropriate to have security clearance, see that unwanted, the persons with unwanted antecedents or precedents are prevented from, are identified so that the private universities remain secular, under no circumstances, the provisions of newly inserted clause D of section 4, as made by the amendment, made by section 2 of the Amendment Act. Full stop. Next para. Under the secular fabric of the country, it is expected that none of the educational institute will involve in activities relating to conversion of any student, faculty, and other staff. And it is expected that every authority, including the university, will maintain a secular character. Therefore, the insertion of clause section 10A is not found to be vague in any manner whatsoever, requiring interference of this court. Full stop. As indicated herein before, the learned standing counsel for the UGC has submitted that the UGC as well as the learned standing counsel for the higher education department have both submitted that for technical courses like engineering, medical, paramedical, nursing, etc., it is not open for a private university to increase seats to such extent as they can or want, but they are guided by the authorities who are empowered to inspect the facilities in the private universities so as to allocate seats for certain technical courses. Full stop. They said, therefore, they said provisions of section 10, capital A within bracket 2 is not found to be derogatory to any act or rules in force in the country. Full stop. A private university cannot be empowered with unbridled powers to increase seats in technical education, which are otherwise guided by many other factors, including overall supervision and control by the authorities like Medical Council of India, AICT, etc. As the petitioner is not agreed by the inspection of the university, which is provided for under 44, newly inserted 44(4) of the Amending Act, in the considered opinion of the court, it cannot be said that any of the provisions of the Amending Act is vitiated by any procedural impropriety. First of all, the said provisions are not found to have any impact on the constitutional governance or separation of powers. First of all, the said provisions are not found to be violative of due process of law or constitutional morality. The next paragraph, though the petitioner has used the term of the said provisions being hit by colorable legislation and disguised discrimination, but apart from reference to the case of Kuldeep Nair versus Union of India, 2006, Black 7 SCC 1, and Maneka Gandhi versus Union of India, 1978, 1 SCC 248, none of the provisions could be demonstrated to be discriminatory. Full stop. As the country has seen localized unrest in several parts of the country on allegations of conversion activities, it cannot be said that the idea behind the legislative intention behind the enactment is, it can be said to be objectionable. So as to enable the court to interfere on the ground of being vague. So. You don't find that this is the direct description of the case, because this proposal 12 is stage 1. First case when the notice number 141, which is in the of India, reduced to this does not count to be an entrance advisory in the kind of is correct or wrong? Oh, sorry, Mr. Singh.
Sir.
In page 23 of your writ petition, paragraph C, you have referred to a decision, 2012 10 SCC page 1. Is that citation correct? Because according to the e-books available with us, this deals with the reference under 143(1). This is not Delhi administration case.
Pardon, Your Lordship, I'm just looking for it.
In the meantime, to the other members of the bar, I think we'll have only time to take up one more matter, I think, because we'll be rising at 4 for the single bench. this week may be a disturbed week. From the week after, we can give you dates. This week would be some inconvenience. Mr. Singh, are we correct? This is
Yes,
not information.
Page to hill question.
Yes, you have checked it.
So just we are trying, but
It is not working.
Okay. In this PL, reference is made to the case of Environmental and Consumer Protection Foundation versus Delhi Administration, 2012, 10 SCC 1. This is at page 23. So, however, as per the ebooks available, the set citation is relates to special reference case number 1 of 2012 and Article 143 within bracket 1 of the Constitution of India.
Party number.
Therefore, no, not therefore, be that as it may, as already indicated above, the amending act has not been found to be draconian so as to invoke the principles of non-retrogression, RETROGRESSION.
Consumer protection.
The private universities do not have such protection as would entitle them to start such courses as they may deem fit and appropriate. Rather, they would have to comply with the directions given by the competent authorities like AICTE and the Medical Council of India for starting courses for certain technical education. And therefore, that right cannot be abrogated to the private universities to open such courses as it may deem fit and proper. Full stop. The petitioner has also questioned the said act on the ground of constitutional sovereignty of the educational institution.
The citation to Malays. The citations, Milord, it shows, Milord, it's not 2012 10 SCC. It should be 2011 13 SCC, page 16.
It's okay, but we don't know. It's very difficult.
Huh.
There may be more cases than one. So whatever but since we found it not being matched, we arrived at a decision. But please give us that citation you are referring to. We'll see it in my
2011 13 SCC.
2011
13 SCC.
SCC.
Page 16.
16.
16. Party name is Environmental and Consumer Protection Foundation versus Delhi Administration.
Thank you.
SCC check. SCC under maintenance. Then it was, the Wi-Fi to.
So in this regard, it may be mentioned that the petitioners relied on the case of Osmania University teachers apostrophe S, S after that apostrophe, Association versus State of Andhra Pradesh, 1987 or SCC 671, to project that academic freedom is an essential component to the right of education. Full stop.
Email ID to which?
In the said case, the Supreme Court of India did not interfere with the power of the power under the Act in reference to make regulations.
Look at it.
Rather, it had approved the provisions of the
GHC?
provisions under which the commissionerate was empowered to decide on the need for, and location of new colleges and courses of study, including engineering colleges.
Yes. Therefore, what's about? Yes.
As the Commissionerate Act was found to be beyond the legislative competence of the state legislature, and it was declared to be void and inoperative. And thus, the said writ petition was allowed by the Supreme Court of India. Therefore, the issue raised in the present PIL was not the subject matter on which the case of Osmania University Teachers Association was decided, Supra was decided. Full stop. Similarly, the case of SK Modak versus H full stop G full stop Lumbaram, LUMBARAM, within bracket 2011, bracket was 8 SCC 1, page 24, on which reliance is placed, also does not empower an technical education institution with such sovereignty, which should enable the institution to impart such courses that we deem fit and proper without, as if there was no regulations to control the activities of such private universities. Therefore, the said amending act is neither found to be discriminatory or in conflict with any other laws. Next paragraph. Certainly, the petition is this PIL is without any merit and the same is dismissed. In Libine versus without issuance of notice on the respondents. Under the circumstances, as the PIL is being dismissed at the motion stage, we refrain from imposing costs.
May not mention our names at the beginning.
Yes, it will come. You give that slip, he'll take it. Not the hello. That's well so. This is someone. Please give it. Please give it.
I'll give it.
You're also there, Mr. Yes. We have
Time-
dismissed the pair. We have refrained from imposing cost.
Time being item 1.
Take up the matter today. Next week. So we'll be rising at the possible next week. This is Alia. I also see you there. We'll be able to.
Matters.
We'll be rising for the day because of the single bench.
I'm told, Miller, but that will not take much time. Because there was an order of the landed single judge. Against that, there was an appeal regarding commissioner appointment. One clause was held to be ultra virus by the landed single
We'll
judge.
take it next week. We'll take it next week. This week we are a bit tied up.
Next, 12.
We'll take it up next week.
Can it not be?
No,
There's
because we'll have to
urgency.
rise at 4 o'clock. There's a single bench of both of us.
That's I told. I'm aware. Only.
Date with you. Next Wednesday. Mrs. Arya, will you be inconvenienced if we take it up on 18th of February?
Can it not be on 12th, Miller?
No, there's some inconvenience. I may have a duty outside.
Next week. Other means may not be there.
May not be there. But you're not very sure. Any day next week. Any day in the week commencing 16th of February.
My lord,
We choose a date.
my lord.
Any date. 16th. Okay.
Number kita di
Okay, here also give a date. Due to positive time, both sides are represented. Due to positive time, matter could not be taken up today. List also and so. Any other matter which we could not take it up, please tell the court master it will be accommodated from the week commencing 16th of February. Unless it's a case of requirement of bail. For that, he may give a early date.
In my matter, bail was already granted, but we have done one mistake in the.
Oh, that 50.
Yes,
51,
51, Lordship.
51.
But Lordship, the earlier order was passed by division, another division.
If I is there, there's no issue with that.
Lordship.
Bench for me is not there.
Lordship, in this case, what happened, we made a mistake in writing the police station of the petitioner in written statement in evidence. So
It's okay,
according,
not on that. What should come is correct.
in fact, her residence falls under the police station of Gauhati, Lordship.
One.
In the causes, you said, what did you say? Ojogi Gopa.
Yes, Lordship.
That is the only mistake.
Lordship. Her police station falls under Gauhati, Lordship.
Any other paragraph in the order to be corrected?
No, Lordship, only that, and Lordship, time may be time limit may be extended, Lordship.
The application is in fact for correction of the cost title of the deed petition. Next, correct, this will submitted that in the address of the petitioner, in the cost title of the deed petition. The police station is referred to as Yogi Gopa. However, the correct police station would be Abhayapuri.
Gauhati.
So, accordingly, it is submitted that though this court by order dated 9/1/2026 had passed in WPC 98 of 2026 had granted bail, but due to the said error, the bail could not be taken. 51.
Yes.
Next one. The as the learned counsel appearing the respective CGC, State and Departmental Council have no objection to the prayer made. This prayer made in this interlocutory stands above. To stop. The petitioner is permitted to submit amended cost title of the said WBC 98 of 2026 to the AOJ. AOJ amended cost title. The AOJ, FT section, on receipt of the same shall be incorporated in the writ petition. Next, brother. Accordingly, common. Ten days further time from the date of the order is extended for the petitioner to appear before the Superintendent of Police, Border, Bongaigaon, and to take bail in terms of directions contained in the order dated 9/1/2026, passed in WBC 98 of 2026. Most of this order shall be read together with order dated 9/1/26, passed in WBC 98 of 2026.
And deeply obliged.
Delivery of orders, item 1, review petition 282/25. For delivery of order, item 2, IA 3877/25.
The writ petition is dismissed on the ground of delay and laches. Resultantly, the interlocutory application also stands dismissed.
For orders, item 3.
In pursuance of the Honorable Court Order that 16/12/2025 Lordship, action was given to the respondent counsel to place the living record. But
So, so here,
yes, sir.
in fact, we have, for some reason, we don't know, I think formally we have not started the hearing of this matter.
Yes.
There were some queries and we heard you and Mr. Nath. Can we hear it on merit?
Yeah,
Start the hearing on merit.
Okay. Lordship, there is a query from you, Lordship, as regard 3 Roman I.
Of paragraph 3.
Yes, Lord.
Yes.
Paragraph 3 of Roman I on
Yes.
16/12/25, Lordship has said
Yes.
that with regard to subpara 3I of the affidavit in opposition, praised for and granted time to produce the relevant records. But here we have said that all the parties, they left the police station at around at about 7:30 or 7:30 o'clock in the morning on 13/4/25, and taking into consideration the compromise between the parties, the inquiry was closed. To that effect, my lord, I have received the GD entry, and it is also a grievance of the petitioner that the FIR copy, which was filed on 9/4/25, was not given to him, is not available to him. It was I have received that particular record I have received. And as regard the hearing on merit, may I? I'm putting it, into detail.
No, first of all, you see, we will have a look into it. If there's a GD entry to it,
Yes, my lord, GD entry is
then
there.
we'll have to file an affidavit so that Mr. Saikia can respond to it.
I'll file, my lord. I'll file.
Otherwise, he will not be aware of the contents.
Lordship. Lordship, I'll bring it on record. My lord, the first page is the letter addressing us. Second, third page, kindly see the GD entry of 14/4/25. This is the brief of serial number 6, brief, GD brief. Kindly take up that, my lord. Now, I, Inspector Bhaskar Malla Patwari, have arrived at the police station and have.
Looking at which page?
Well, the particular record I have sent, my lord.
Yes.
I have placed. Kindly see serial number 5. Entry dated. First is 10/4/25 entry. Second is 13/4/25.
Yes.
Next, my lord.
14/4/25.
14/4/25.
Yes.
6, serial number 6, GD brief. Now, I, Inspector Bhaskar Malla Patwari, have arrived at the police station and have taken charge of PS. It is to be mentioned that SI Kamal Jyoti Thakuria has informed that in connection with this full PS.
Just a moment.
For second page, after the forwarding letter, that is the GD, my lord. Yes.
You see, so far as we are concerned, we have a view against the state in this matter. The reason is, you will please come to that GD entry.
My lord.
GD entry says, on so-and-so complainant, so-and-so offshore has lodged an FIR regarding non-payment of payment of so and so and non-refund of the amount. Correct? It's non-refund of the amount. Therefore, in this case, there is no, otherwise it doesn't reflect any offense to be have committed. Correct? That's number one. Now come to the second entry. Second page. Today at 12/4/25 at about so and so, Kamal Thakur with his staff, one person, namely so and so, was brought to Dispur police station. Now, once you bring someone, it's nothing but an arrest.
No, for interrogation.
41, no, you could have given him a notice under 41A.
Yes.
Don't give that. You could have called him. You don't go to for non-cognizable offense. You don't go to a person, bring him to the police station.
Yes. In fact,
No,
I'll
file it. File an affidavit.
I'll file.
Because Mr. Saike would have to respond to this.
Yes. And with the third page of the GD.
That becomes immaterial. Once. That's why we said this, the third one becomes immaterial. They refer to a compromise, but then this interrogation was not an interrogation at all. We just kept him till they signed this agreement, compromised the matter and went off. What was the investigation done?
It was an inquiry. It was an inquiry according to them at that point of time, because after receipt of the FIR, he was contacted over phone and he did not respond. That is
I'll tell you something.
I'll file the affidavit for that. Mother.
And in this, and the life of one of them made a statement to acknowledge it will be the life of one. You can it allowed to an industrial and the virus goes to the you see, I am remembering this story about BTS 55 years. But it is very years. And you can actually there that. That says one of the fingers from the he came to the house of the other person and they said, in the top of the antenna and Robert was kind of so we are in this and the thinking was so he said that by thinking lost.
Left shoulder. Left.
The background that the vibrate flow. Place level 4.7. Games are very.
I'll bring it on record.
Mr. M. Saikar and counsel for the petitioner as well as Mr. D. Nath, the senior government advocate. Pursuant to this is paragraph 3.1 is what?
3.1 Of the affidavit and affidavit
No,
and
no, no,
opposition.
there is order.
1612, no? 1612,
16, 12, 20. Johnny Sinigam David submitted that pursuant to query of this court as recorded in the order dated 16/12/2025. Yes. Obtained and produced the relevant records of the police station relating to GD entry number 54 and the and subsequent entries in connection with the said case. It is deemed appropriate that the concerned authority of the state would file an affidavit to bring on record those documents so that the petitioners, the petitioner would have notice of the same. Next para. On the next date of listing, if time permits, the court may finally have them filed. Expect the affidavit shall be filed at least 2 days prior to the next date of this league. Very strong. Tell us when.
Kindly take it up in the last week, Manoj. Last week of February.
Give us a date, we'll list it then. You'll get it. Take your time. Whenever you want.
25th, no?
25th.
25th or 27th.
We are making it 26th.
26th.
26th of April 2026. At least 2 days before, give a copy to him.
Manoj.
Be prepared on the next day.
Here also.
The record produced are returned. Before last time, list also. Sorry. We think we should not have disclosed our mind. You will also find, I just forgot, with these facts. There was a matter under similar circumstances in Arunachal bench, where the police officer had called the both sides to have a negotiation in the police station. It was a very harsh view. I won't remember the case. It was about 3 years back.
I'll try to look at that.
But the senior counsel holding the brief was Mr. Mukherjee. Because this police station cannot be converted into a what you call arbitration or conciliation proceeding.
Yes.
That was the view taken, that they can take process, they can arrest people, and call people and then have negotiation on the table. That is something which may be impermissible.
Yes. In fact,
it violates your the directions contained in the DK bus. Leave it to you, but you plot your own solve, but
logic.